Did you know that an attorney who uses a subpoena to compel a witness to come in and testify at a pretrial deposition can get into a lot of trouble here in New York? Would you like to learn why? Come join me as I share that information with you. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. A subpoena is a document that compels a witness to do something. We're either going to compel a witness to come into court and testify, or we're going to use it to compel a doctor's office or a hospital to deliver records to the court so that now we can use that as evidence in your trial. However, in past years, did you know that it was possible for an attorney to use a subpoena, a document which allows somebody to compel someone to do something, and force them to actually come to a deposition, which was a pretrial question and answer session? Many years ago, lawyers in New York were allowed to use that document to do that. However, things have changed. And now if an attorney tries to use that on their own to get a witness to come in to testify, the attorney can get into a lot of trouble. They can get sanctioned, they can get fined, because it's not proper to do anymore. So what do we do if we want a witness to come in and testify during a pretrial deposition? If the witness that we want to come in and testify is a party to the lawsuit, they've been served before, and now they're part of the process, we then notify their attorney and say, listen, we need your client's deposition. And then the attorney is obligated to set up and schedule that question and answer session. And if they refuse to do that, or if the witness refuses to come in, we now have different ways to compel them to come in by going to the court and having the court compel them to come in at a scheduled date and time. But what if this particular person who we want to come in and testify is not part of the lawsuit? How do we actually get their testimony? One of the ways to do that is with something called a non-party witness subpoena. And if they are in the state of New York, we can take a non-party witness subpoena and actually deliver it to that particular person and compel them to come into court. What will typically happen is we're going to take that document, that non-party witness subpoena, which is simply a piece of paper that says, hey, you have certain facts and information that's relevant to this particular lawsuit. We want to question you at a question and answer session under oath in my office. And now you need to come in at the appropriate time. What happens is we give that piece of paper to a person who then delivers it to that particular witness. That's known as a process server. The witness who gets it, what they will typically do is they'll get it, read it, and then they will hand it over to their attorney. Their attorney will then get in touch with us and then schedule the deposition. So why do I share this information with you? You know, I share this information with you just to give you an insight and an understanding into the legal process, into what goes on behind the scenes that you typically are probably not familiar with. Chances are you have questions and concerns about your own particular matter, and if your matter happened here in the state of New York and you have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I do this every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Jerry Oginski here in New York. Thanks so much for watching.